Hello, everyone. This is Tom Fox back again with Matt Kelly for another episode of the award-winning Compliance Into the Weeds. Welcome back, Matt.
Hello, Tom. Good to be here.
Matt, surprisingly or not, today's topic is all things monitors and monitorships. So were you shocked to find that the DOJ memo on monitorship selection was taken down, or just another day at the Trump administration?
I was surprised at the timing of it because I actually have been checking the DOJ fraud section website from time to time. But at some point, I would guess within the last 2 weeks, I do not check this website every day. I'm not that much of a nerd, but I do check it fairly often. And I had realized within the last 2 weeks or so, it is no longer there. It has been disappeared, perhaps off to a prison in El Salvador. I am not clear on that. But now, if you click on, the link is still up there, and the actual piece of text that says selection of compliance monitors, if you click on that, you get a page not found. The actual policy is now gone.
For the first time in Compliance Into the Weeds, we were going to make an in-podcast correction. Matt, you are that big a nerd.
All right.
With that, okay, it's taken down. You and I have actually speculated, not if, but when this would happen. But does this really have any significant meaning for compliance professionals?
It's hard to say. And there could be any number of reasons why the department decided to take it down. I submitted a request into the Public Affairs Office. I did not get a response. For all we know, maybe they've laid off those PA people at the Justice Department too, like layoffs across the government. But it is possible that they just took down this policy because it does include the phrase diversity, equity, and inclusion, the words that dare not speak their name in Trump times anymore. Maybe it was just that. But more largely, I think we could all see the tea leaves or see the writing on the wall that clearly the Trump administration was going to retreat from using compliance monitors more broadly. They have not, I don't think, formally said, we will not use compliance monitors. And I actually would be surprised if they went that far with a categorical declaration that they're not going to have any more monitors. But they do, I guess, want to revisit the use of monitors. They're going to be more judicious in them. We can talk about some of the press reports about who has or has not had monitorships repealed early or been told you're going to still have them. And we should also remember that monitorships have been somewhat rarer in the last several years anyways. I am not surprised that this happened. I don't know exactly why it happened. I am not entirely sure how much of a practical effect it will have on companies. And we can talk about some of the other monitorship substitutions that we have seen. We could also talk about how there are at least some states that seem gung-ho to do monitorships on their own anyways. There's a lot to discuss.
Matt, if we step back a little bit, and I was thinking about this in preparation for today's pod, I would say we've seen at least 3, maybe 4 major cycles of stepping back from monitorships, moving forward with monitorships. And if we go back to the first decade of this century, we saw a lot of monitorships, particularly in the FCPA world. There was a pushback because of some of the exorbitant cost, two at over $50 million a year, which caught the ire of at least one U.S. district judge. And so we saw a bit of a pullback after that. Then they picked up again, and we had the Benczkowski memo from former Deputy Attorney General Brian Benczkowski, which set out a rigorous formula for selection of monitorships. And I believe in the first Trump administration, and we saw a little bit of a cutback then. But here, certainly since the Biden administration, we have not seen a lot of monitorships. And you noted, I think over the past 2 years, there have been none, at least in the FCPA arena.
Yeah, that's all true. We should remember our history that once upon a time, monitorships were, I don't know if we want to say they were subject to abuse, but we seem to have a lot of high profile, very expensive monitorships going to people who had lots of close ties with the current Trump Justice Department leadership across several administrations, Republican and Democrat. But it would be somebody like the former leader of the FBI, Louis Freeh. He was a compliance monitor. Former Attorney General John Ashcroft, I believe he was a monitor. Former Deputy AG was another monitor. and back and forth. The Benkowski memo to try and put some structure around this, that was a good idea. And then during the Biden administration in 2023, the then head of the criminal division, Assistant AG Ken Polite, who we have talked about numerous times on this podcast over the years, he tried to put even more structure around it. That is where they dropped in the diversity, equity, and inclusion reference. And like I said before, that alone would be enough to get it stricken from all records of the federal government under Trump 2.0. But it was weird because eventually one judge in the Boeing case, which is still ongoing, they called out the Justice Department on this. This was a Republican appointed judge down in Texas overhearing that Boeing case who said, what is this with the DEI thing? Does that mean you're having a substandard monitor? And the Justice Department was trying to say, no, by diversity, we mean they're not all going to be big law partners charging $2,200 an hour. I think they are largely still all big law people charging $2,200 an hour or so, but they're not all ex-deputy AGs or ex-FBI directors. I guess that's progress and diversity, not sure. But anyways, so there was a lot of that. But then, Tom, to your point, we should also, by the numbers, look and see in the first Trump administration, there were more compliance monitors than in the Biden administration. The Biden administration in the latter half in 2023 and 2024 had no compliance monitors published by the fraud section, and they do publish a list of who gets what monitorships. There was one just at the very end of the administration in 2025 before Biden pieced out, but that's 2 whole years. Now, what had happened then was that the Justice Department was trying to beef up its capacity to sort of act as its own compliance monitor. And Tom, I don't know if you and I ever talked about this in prior podcasts, but basically we were seeing a lot of FCPA settlements without a monitor, but you would have these periodic reports that the offending company had to make directly to the fraud section. And they would chart out the progress you're making on various compliance undertakings you promised to make and whatnot. So it was really monitorship just done by the fraud section because they had their own compliance counsels or compliance expertise within the department. And so they said, okay, we're not going to have a monitor. So that was that for all of 23 and all of 2024. We had this one last compliance monitor announced in early 2025. But we still now have this great puzzle of what will the Trump Justice Department do from here forward with compliance monitors. And we can talk about that, but that's been the history from way back when until right now.
The other thing you hit it at was there are actually cases where monitors have been appointed. One certainly notable one at the federal level is TD Bank, but we've also had, and you posted another blog today about another state monitorship. So could you maybe talk about those and see what, if any, we might be able to tease out of those events? Or are they so anomalous that they are really standalone and we can't draw greater lessons?
We don't know. That's the honest answer. Here's what we do know from various press reports. So, for example, Glencore did get to exit its monitorship early. It exited the monitorship with the blessing of the Trump Justice Department several weeks ago. That doesn't strike me as abrupt departure because that monitorship was scheduled to conclude by May of this year anyway. So they got out 3 months before the end of a 3-year term. On the other hand, according to published reports, apparently the Justice Department has told TD Bank, no, you are keeping your monitorship. That had just been assigned as part of the resolution in October 2024. They had that mammoth anti-money laundering scandal, and TD Bank just confirmed who that monitor would be earlier this spring. Typically, after the resolution that says there will be a monitor, there's a gap of 30, 60, 90 days or so before they actually pick who that monitor is. So even though this settlement came for TD in 2024, the monitor was not assigned until 2025, but that is now in train. And apparently, according to published reports, the department has told TD Bank that train's going to keep running. You still have the monitor. I have read yet more reports saying that the Justice Department has told other monitors who are ongoing with their work to pause their work. They didn't name any companies. They said there were a handful. I don't know what a handful means. I'm guessing 3 or 4. But there was a big article in the Wall Street Journal just today about the decline in white-collar crime enforcement that everybody is expecting from Trump and that we are already seeing from the Justice Department. One part of that step back from white-collar enforcement is going to be not just fewer monitors in the future, but telling current monitorships, slow your roll, freeze your roll, and don't be surprised if we put an end to your roll earlier. So we might see more like that. But then, Tom, to your point, just last week, we saw a monitor imposed by the state of New York. That was done by the Department of Financial Services, DFS, against Block. That is the online payments company that owns that peer-to-peer digital wallet payments app, Cash App. And so Cash App had some pretty bad anti-money laundering practices for a couple of years in the late 2010s, early 2020s. Just reached a settlement with New York state regulators because Block, like many financial firms, does business in New York, so therefore they are subject to DFS. And DFS slapped a $40 million fine on Block and imposed a compliance monitor for 1 year. So it is still possible to have a state impose its own compliance monitor. They're not even the most, they're the biggest example, but they're not the only recent example from states. There was another case in Minnesota, also announced just last week, where there had been a False Claims Act case at the federal and state level because Minnesota was piggybacking its own false claims allegations on a federal False Claims Act against a pavement contractor, of all people. And the pavement contractor had apparently been falsifying test results on the quality of its asphalt. So the asphalt pavement contractor pleaded out to or reached a settlement on False Claims Act charges, $1.3 million fine, and a compliance monitor who reports to the Minnesota State Department of Transportation. So I do not think it's going to be a former attorney general managing that monitorship. But nonetheless, there are state compliance monitors for state level offenses. And you can certainly imagine that there might be others in, say, a consumer protection settlement, a privacy claim, something like that. Like, monitors are not going to go away. But the question is, if you're a large company and you have gone from one significant federally appointed compliance monitor to perhaps multiple smaller scale state level monitors, has your situation really improved? I don't know, because you might wind up having to make multiple reports to multiple people who each will think they're the most important state officials or compliance monitors in the world, but maybe if they're just reporting out to a State Department of Transportation, with all due respect to DOT engineers and compliance monitors out there, that's not quite the same heft as a federally appointed monitor on some sort of federal corporate corruption settlement. So I don't know what all that means, except the compliance need, the compliance capability, that's not going to go away just because the Trump administration is going to put its hands over its ears and say, we're not going to enforce anti-corruption law anymore.
Would you say maybe a few thoughts about in the international arena monitorships? Because in the Airbus case, we had multiple monitors, specifically a French monitor. And in Glencore, the United Kingdom had their own action against Glencore, and they appointed a monitor. So I think we could actually see monitorships in the international sphere in addition to perhaps state or other U.S. localities.
Yes, that's decidedly possible. And again, just because the Trump administration might walk away from FCPA enforcement, which maybe it will, maybe it won't. There's at least a few FCPA cases that they've already decided we're going to keep going with them. So I don't know that FCPA enforcement will vanish from the United States. But even if it did, we already see other international overseas regulators and law enforcement stepping up to say we are going to keep going with our own anti-corruption laws, and we're going to keep going with multi-country jurisdiction and enforcement. And those are the kind of big cases that wind up with a compliance monitor sometimes. I have no idea how rigorously other countries might embrace the idea of compliance monitors. It is a thing. It does happen. However, for compliance professionals at large corporations, I think the key takeaway is that You can't assume that these mechanisms are going to go away just because one particular country, our own, is saying they're not going to do it. You really need to think long and hard about, are we going to diminish our compliance capacity as a business because we think the enforcement risk is lower from one particular voice? I was about to say jurisdiction of the United States, but the US is actually many multiple jurisdictions. So just because the feds in the US say we're not going to do it anymore, does that mean you can dismantle all your compliance capabilities? Like, absolutely not. Are you serious when people might say that? And I know that there are company managements out there who think that they can. And I know this because compliance listeners are emailing me on the down low to say, this is what my management team is trying to say, and I think it's crazy. What do you think? I'm like, yeah, dear listener or dear reader, that is crazy. And it's not going to be a good idea because the enforcement risk is still going to be out there, coming from different directions. And maybe, as I've said, if you go from one heavyweight to 4 bantamweights, if you're still getting pummeled, you still need defense mechanisms. You still need some way to demonstrate that your compliance capacity and capability is there. So I don't know what to say about it. There's a lot going on with monitor ships in particular, but I don't see any of that as a green light to therefore eviscerate your compliance capabilities. That seems very short-sighted to me.
So could some of the responses we could have at this point be, perhaps one is, this is just one more iteration of the ebbs and flows of monitor ships, and we need to wait and see what it may mean? Could another response be, as you just ended with, monitor ships are only a relatively small, if yet painful, part of a compliance enforcement action, and so if there's a compliance enforcement action possibility, you still need to have a robust compliance program? Or are we really in a wait and see timeframe?
I think we are going to have to wait and see. There still is going to be a certain utility in having compliance monitors as a card that federal prosecutors could play. So I don't think we're going to see a statement from the Trump administration Justice Department saying there will be no more monitors while we are in power. I think they're just going to say we're going to have this set of criteria, possibly quite limited, about when monitors will be assigned. And then after that, they just might not assign any. But again, can you take any of that to the bank? Come on, folks. You can't take anything that Donald Trump says to the bank. And you can't take this Justice Department and what it says to the bank. There's still going to be an immense number of variables that prosecutors will weigh and that you're going to have to weigh before they decide what a resolution is going to look like. But the best I can give you is wait and see. There's even just what we discussed today. Clearly, some monitor ships are ending early. If reports are to be believed, some of them are going to continue. And we will just have to wait to see what the leadership at the Justice Department comes forth and says. And we don't know when that might be.
Matt, that seems like a good point to end this podcast on. I want to tell our listeners we will be off next week, so there'll be no Compliance Into the Weeds on April 23rd, but we'll be back with you on April 30th. So until then, Matt.
Thanks, Tom.